It started with a game of chance with no luck of ending well for nearly every player involved.
It was a game of dice that erupted into gunfire. 4 men shot. They fled from Bell Street to Auburn Avenue when police found 3 of them bleeding, another dying.
Thousands of dollars were at stake. 2 men branded guns after one accused the other of cheating on a hot summer morning in June 2014. Dexter Beard shot 4 times, survived. Selaman Balai, hit 5 times by bullets, did not.
Right now we're actively working the crime scene and seeking witnesses to try to determine what happened.
6 months later, a Fulton County grand jury indicted Beard for Balai's murder. A trial convened a few months later. District Attorney Paul Howard.
The witnesses came in. They positively identified the defendant. The jurors heard it, and they convicted him. I don't have any doubt that he's guilty.
Judge Doris Downs sentenced Beard to life in prison. But then, 3 years later, something extraordinary happens. The judge took another look at the case after Beard filed an appeal and determined the case was riddled with conflicting evidence and credibility concerns because many of the witnesses were drinking.
The jurors were all aware of that. And those facts that the judge pointed out, it does not mean that people are not credible.
They take the meds.
That didn't matter to Judge Downs. In October last year, she determined the original jurors got it wrong, named herself the 13th juror, and ordered Beard a new trial, reversing his conviction. She then immediately retired from the bench. So she names herself the 13th juror the same day that she's retiring.
That's the day that the opinion was delivered.
Judge Downs declined a recorded interview, but over the phone says her retirement was not sudden, rather planned a year in advance. She blames the delays on obtaining court transcripts and a heavy caseload. A review investigation uncovered Downs isn't the only Georgia judge to do this. Last year, Bexar County Judge David Moats named himself the 13th juror, reversing the murder conviction of Paul Hamilton, a former judge himself. Moats provided little reason why. Do you want to provide any explanation of why you gave him a new trial?
The Georgia Supreme Court explained it better than I can.
But don't you owe it to your former constituents? Judge Moats retired days later. In Fulton County, Judge John Groger also named himself the 13th juror last year, reversing the murder conviction of Quantavious Holmes, a repeat violent offender. He retired weeks later.
I guess I'm wondering if what you're doing is wholesome. Why are you waiting until the last hour of your service to the bench? It says to me and it says to others that something is not right about the judge's action.
Howard appealed Judge Downs' decision to Georgia's Supreme Court. But the Supreme Court justices affirmed the lower court's ruling, allowing Beard's new trial to continue. In fact, every 13th juror case appeared before Georgia's highest court has been approved to move forward, essentially giving judges across the state a green light to reverse convictions each time they think the jury gets it wrong. Justice David Namias.
I mean, the judge is the 13th juror.
Yes.
It's nice if he gives you a chance to weigh in on your views on the general grounds, but there's nothing in the statute that requires it.
Another justice, Sarah Warren, called Howard's appeal bizarre. 2 weeks later, Howard responded with these T-shirts and a tweet saying, "We are bizarre, bizarre for justice."
And for the judge to seemingly ridicule our office, I thought was highly inappropriate.
This past November, Howard sent this letter to Governor Brian Kemp asking for his help to amend the 13th juror statute, writing he and other district attorneys are concerned the law can single-handedly undo all the hard work of a criminal jury. Gwinnett County District Attorney Danny Porter, a Republican, is among them.
If people can't rely on the results that are given by juries, then you can't rely on the system at all.
Howard, a Democrat, agrees.
That's not what the founders of our Constitution intended, And I just don't think they ever intended for a judge to simply undo the work of a jury.